Welcome to the International Law Summer Institute guest faculty lecture 4.0, and it's a real pleasure to have Armand de Mestral as our guest speaker today. The issue of investor state arbitrations has been something that's always really fascinated me as an environmental lawyer because of the interplay between investment and the environment, and particularly in the NAFTA context, because Chapter 11 of NAFTA was always one of these issues that I personally looked at and felt it was a bit like bulk water in Canada. You know, it seemed to be much fuss, but when you actually looked at the cases and what went on, and perhaps until the Bilcon case that just came out, which is changing my view a little bit on investor state arbitration. But it's such a nuanced area and such a controversial area for many good reasons, and I think it's certainly an area that deserves a sort of comprehensive taking stock of where we are with investor state arbitration, because we seem to be moving into perhaps another era with a number of trade and investment agreements on the horizon where investor state arbitration is taking a significant or potentially significant role. And in that regard, we have really a first-rate navigator of this complicated landscape. Armand de Mestral is a professor emeritus at McGill Law School. He's currently the Jean Monnet Chair in the Law of International Economic Integration. He teaches and researches in the area of trade law, international arbitration, and the law of European community. And he is an extremely well-known and well-respected international legal scholar in Canada, and indeed all over the world. He's served on WTO and NAFTA dispute settlement and arbitration tribunals, and also has served as the president of the Canadian Red Cross. He's a member of the Order of Canada, and brings a huge amount of expertise, and is currently bringing that expertise to CIGI as a senior fellow. So it's really with great pride and great delight that I introduce Armand de Mestral.
Well, thank you very much, Neil. It's a pleasure to be here, to have an opportunity to speak to, and also I hope hear from such a varied group of students of international relations, international law, and international affairs. Now, and also, of course, I'm very pleased to be associated with the CIGI. We're working toward a conference on September 25th, and possibly a publication subsequent to that. Now, my topic is a rather focused one, and indeed I'll just give you the precise topic that I'm focusing on in the study is whether it's appropriate for developed democracies to have recourse to investor state arbitration. So responding, if you will, to the kind of concerns or unease that Neil just alluded to. But I hope I can show you that this is not just a narrow issue. In fact, it raises a lot of cross-cutting themes in international relations, international law today. We're looking at the whole question of the pertinence of the treaty protection of international investment. We're looking at the confluence, if you will, the coming together of international trade law and international investment law, two fields that for quite a while and still in many ways are rather separate, but seem to be coming together. we're talking about the significance of regional trade agreements as opposed to, or sometimes in conflict with, the global system epitomized by the WTO. We're looking at the issue of the universality, the appropriateness of the universal solutions versus particular solutions. Should the same rules apply in the same way to all countries? We're also looking at a very political question, a very serious question that Canada may have to answer fairly soon in the context of the CETA, because we have an agreement with the European Union right now which includes investor state arbitration. We're hearing more and more from certain quarters, but not necessarily from everybody in the European Union, that they're uneasy with it, and the one committee of the European Parliament has even said it ought to be withdrawn from CETA. That, of course, is just the opinion of one committee, not of the member states, not of the Commission, not of the EU as such. But it's nevertheless something, the text of CETA is being finalized at this moment, and it's conceivable that we may have to look again at something we assumed was settled. So that makes it, I think, a very timely topic, and whether it will be resolved by September 25th when we have the conference, I'm not sure. But so what I'd like to say, talk to you, first set out briefly, how did we get to this situation? Then, secondly, I want to review some of the criticisms that are made of investor state arbitration. And then, thirdly, look at some of the solutions that are proposed. And finally, if there's time, to look at some of what I think are the options that are realistically available to the Government of Canada at the present time. Now, as I say, the topic is the pertinence, the propriety of investor state arbitration between developed democracies. And why am I asking this question, and where does it come from? Now, since roughly 1959, we've seen the development of roughly over 3,000 bilateral treaties designed to protect foreign investment moving from investor countries to investment in countries receiving investment, mainly between developed and developing countries. We've seen the emergence over this 50-year period of roughly 3,000 treaties. And in recent years, we've seen an additional, if you will, complication, that many of the regional trade agreements, so broader trade agreements like NAFTA. NAFTA was really the first one that really set the course 20 years ago. We're seeing chapters on investment protection, which written into trade agreements, so that trade and investment law are coming together. And a central feature of most of these bilateral treaties and of these texts like NAFTA Chapter 11 is a system of arbitration which allows the private investor who considers that their investment has suffered economic loss due to violation of the standards of treatment set out in the treaty, the investor is permitted to seek arbitration directly against the state that they think has caused its economic harm. And this is what is known as investor state arbitration. You also see the expression investor state dispute settlement. I find that a little ambiguous because that might embrace also public dispute settlement. What I'm talking about is a private investor suing a government, which makes this a very interesting issue for international law generally, because normally private parties are not the object of treaties, not subject to treaties, and don't have standing in treaties to seek remedies. This is a rather unusual situation. The private company can sue the state directly if they consider they've suffered economic loss. Now, as I say, most of these treaties and the whole paradigm as it was originally conceived and worked out since 1959, the first modern treaty, most of them are between developed and developing countries, capital exporting, capital importing. And the idea, certainly of the first one, between Germany and Pakistan, was that the Germans wanted to invest in Pakistan, but German investors went to their government and said, you know, we're not too happy with the state of the law or the state of the courts in Pakistan. We're not sure what happens if we have difficulties with the government. We'd like things to be set out in a clearer fashion. So please negotiate a treaty, and in that treaty set out certain standards of treatment, like national treatment, most favored nation treatment, fair and equitable treatment, non-expropriation except for public purpose, things like that. Put these things in the treaty and let us have a remedy by way of arbitration rather than going to the courts of Pakistan, which we are nervous about, probably with some reason. Now, I don't pick out Pakistan, but it was the first country. So you get this system, you can, a private investor can seek arbitration. What they seek is damages, monetary damages, if they consider they've suffered economic loss. Now, the treaty from the very first has always been drafted in reciprocal terms. So it simply says, if an investor from one side considers they've suffered economic loss due to violation of the treaty in the other country, they can seek arbitration. It doesn't say it's one way. It doesn't say only Germans can sue in Pakistan. It says either Germans can sue in Pakistan or Pakistanis can sue in Germany. But back in 1959, nobody expected that somebody from Pakistan or India or Indonesia or what have you, one day might want to sue in Germany. So the assumption was it's one direction. And I think it also has to be said, nobody objected. Or if the Pakistanis didn't like it, they said that's the price of doing business and we'll accept it. Nobody said this was an unfair or inappropriate way of setting up and protecting the interests of investors at the time. But things move and things change in over 50 years. And today we're in a situation, first of all, we have more than 3,000 bilateral treaties and 60 plus trade agreements with investment chapters. And over the 50 years, not massively out of the 3,000 plus, but nevertheless, there's a certain percentage of these treaties where two developed countries find themselves equally the object of the treaty rights. Give you an example. When Canada and the United States negotiated our bilateral free trade agreement in 1988, we had an investment chapter, but no investor state arbitration. Come the NAFTA negotiation, I think it was the American government in particular, felt that there should be investor state arbitration in the NAFTA Chapter 11 eventually with Mexico, and the Canadian government thought it over and decided, all right, we'll go along with this, and they used the U.S. model treaty as the basis of Chapter 11. But that meant that almost for the first time, it wasn't just a U.S. investor in Mexico that might sue the Mexican government, or a Mexican that might sue the Americans, but it meant that an American might sue in Canada, or a Canadian might sue in the USA. And little by little, we have seen the increase in these treaties involving not just a developing and a developed country, but now we're seeing a number of these treaties where developed country, 2 and more developed countries may be affected. And other examples would be the International Energy Charter concluded between Europe and countries of Central, or the Caucasus and Central Asia. But that binds a great many EU countries, as well as these countries of the Caucasus and Central Asia. So it means that not only the purpose was largely to protect EU energy interests in these countries, but now, from time to time, we've seen situations where one EU member state or European country investor in another European country can also invoke the Energy Charter. And there are a few other examples. Australia has just signed a trade treaty with investor state arbitration with Korea. Japan, Switzerland have a treaty dating back to 2006. And the biggest single group are the treaties that used to be between major European Western democracies and communist countries of Eastern Europe. Those countries, of course, are now democratic countries, members of the European Union, and there are about 190 of those treaties in place, which the EU contests and says they all ought to disappear, but so far they haven't disappeared. So there you are. You have a situation where you have a paradigm developed in an interesting body of international law, 3,000 treaties. It's quite significant. How many of you can think of another group of treaties where there are 3,000? Not environment, not human rights. I'm afraid tax and air law are the only two. Not very exciting, but there we are. So it's a significant block of treaties, but these were developed for a particular context and a particular purpose, and now we're seeing it shifting and affecting everybody, and particularly developed democracies. And as you are doubtless aware, not everybody is comfortable with this. And I've recently done, for the course of my studies, I've been examining the situation in Europe and in Australia, in Japan, Korea, not to mention the US and Canada. And out of those governments, as far as I can see, only the government of South Korea is actually comfortable with the idea that they might be sued by a foreign investor. As far as I can see, the Canadian government never likes it too much. The American government doesn't like it too much. There's a raging debate now provoked by Senator Warren. The European Parliament has got very excited in the anticipation of a trade treaty with Europe and the United States. And in Japan, in anticipation of the TPP, where investor state arbitration is also included, in both countries, you were hearing the argument, we can't have this. We'll see all sorts of American corporations lining up to attack our most sacred pieces of legislation, and suddenly the TTIP and the TPP, one in Europe, one in Japan, have become major political footballs. And we may, in Canada, as with between Canada and the EU, we may, in fact, be affected by this. So what began as one kind of paradigm has been generalized, and now many other countries are experiencing the impact of the model. One country, at least, Australia, for a few years seemed to be saying, we do not want to have recourse to investor state arbitration at all. We don't think it appropriate, and they made a big point when they negotiated with the United States in 2004, 2005, to say, we don't need investor state arbitration in our investment chapter of the trade agreement with the USA. And the Americans said, okay, we'll trust your courts, you trust ours, that's fine. And Australia seemed to be saying for a period, we're forswearing this technique altogether. But now recently, they have agreed in the same week to one trade treaty with Japan without investor state arbitration, and in the same week, they concluded a deal with Korea with investor state arbitration. It said that the Koreans wanted it very badly, and they were willing to give up and allow the importation, terrible concession, of 1,000 tons of Australian beef into South Korea in order to get investor state arbitration into their treaty. This is the first time they've traded beef for investor state arbitration. So we're dealing with a situation where developed democracies are the object of legal action, of arbitrations by foreign investors as well as other countries. And indeed, Canada probably has more experience with this than any other, because we've had Chapter 11 of NAFTA since 1994. Canada has been sued in arbitration 31 times. And as far as one can make out, government doesn't really like it. And there's a large body of opinion in this country that says this shouldn't happen. And it's become, I think, a matter of some course. And we have three of the most principled objectors to investor state arbitration writing internationally, Professor Van Harten of Osgood, Schneiderman in U of T, and Howard Mann, who's a lawyer in Ottawa, have all written very eloquently suggesting that investor state arbitration generally, not just between developed democracies, but generally is not an appropriate policy, and that we should drop it. Now, what is wrong with investor state arbitration? And here I have to warn you. You've heard probably quite a lot from the critics. Arbitrators tend not to stand up and defend their own turf, because immediately somebody will point out, well, you're defending your own turf. You know, you have a financial interest. Of course you're going to say it's a great thing. So nobody has been defending or explaining investor state arbitration very well. And indeed, that's happening right now in the European Union when there's quite a concern publicly about it being included in either CETA or the TTIP. The Commission doesn't really know how to respond and explain in positive terms why investor-state arbitration is not necessarily a bad thing. Now, the critics will say they're not responding because they don't have any good arguments, but I just warn you, you're hearing from the critics, there are two sides to this argument. The fundamental reason for all this is that we have a system where trillions of dollars, or yen or pounds or whatever you want to call them, are invested around the world, and you have a system that's set up to reinforce the legal protections that have been given to these vast investments. So there is a purpose behind it, but it's not a purpose that you'll hear the president of major corporations standing up and explaining every day of the week. But interestingly, a country that has passed from being the receiver of foreign investment to becoming a very significant foreign investor, China, has now taken and has now negotiated recently about 40 new agreements with investor-state arbitration, and every agreement China concludes includes investor-state arbitration, so that be aware that there are more than one side to the argument, and the critics have the high ground, but there aren't many people out there answering them. And in part, my study is an attempt to try to see what the arguments pro and con the whole system may be, particularly as it affects developed democracies. Now, going through all the criticisms that are given, I think would take more time than I have. Let me just, maybe I'll just read out a few of them and then go over some of them. One of them, it's a privilege given to foreigners. That's bad. This is a privilege designed to protect and favor multinational enterprises. Not good. We have courts in this country. Why don't we let the courts resolve any differences that may arise when foreign investors have problems? Investor-state arbitration is undemocratic. It's conducted in secret. It's conducted by arbitrators whom we don't trust. They serve several masters. We're not sure they respect public policy. We don't trust them. Investor-state arbitration, and you hear this often, is an opportunity for foreign companies to attack and challenge legitimate government policies. Investor-state arbitration has led to a regulatory chill, so that governments and officials are afraid to regulate. Or another line of criticism, investor-state arbitration, the standards applied by arbitrators are too vague. They're open to abusive and overbroad interpretation. In particular, people point to the question of whether the concept of fair and equitable treatment is not just too open-ended. But most treaties also prohibit performance requirements. That is where foreign investors are allowed in, but only on condition that they purchase locally or export their products or what have you. The concept of expropriation, it's said, which is always protected by these treaties, is too broad. And in particular, the concept of indirect expropriation lets arbitrators do anything they like. Another criticism of the 350-odd cases that we've seen in the last 20 years, the decisions are unpredictable. They're not necessarily coherent. And there's no way of correcting them. There's no appeal process. Investor state arbitration, you'll hear, is not necessary. Investors are adults. They invest. They take their risks. Why should they be given these additional protections? Or finally, this is what I'm examining in part in the conference, this may be a reasonable option between developed and developing countries, but it's not an appropriate procedure between developed democracies. Okay, you've heard all that. Game over, eh? This unmitigated evil. Why would anybody write that into a treaty? Why would any government support it? What kind of craziness has gone by? Have we allowed? As I say, it's easier to present the criticisms. The answers are often detailed and technical and perhaps for many people not entirely satisfactory. And I think maybe I should leave it to the question period to go into a number of them, but let me take up one or two. It's said that what we need and what's lacking is some kind of appeal process, because arbitration normally involves a decision. That's it. The normal law governing arbitration is simply you choose your own judges, you indicate what law they are to apply, they hear you, they apply the law, they give a decision, and that decision is final and binding. And that paradigm has been largely carried into investor state arbitration. So people say, in this case, at least what you need is some kind of appellate process. And an appeal process or an appeal court would enjoy greater confidence, greater respect. It would also bring greater coherence to decision-making and to the range of, and the arbitrators would feel more constrained in the way they went about their business. So, sounds like a great idea. And people often add, what we want is something just like the appellate body of the World Trade Organization. Look at the wonderful job it's done over the last 20 years. It's brought a great deal of order and rigor to thinking about the rules of trade law as applied by the World Trade Organization. So that's what we want for international investment law. And that's what we want to discipline investor state arbitration. Okay, sounds good. And you may have heard the aphorism, the best is the enemy of the good. It's the best, maybe. But the analogy with the World Trade Organization, or the appellate body of the World Trade Organization, first of all, doesn't stand. The World Trade Organization has one body of law. The appellate body applies one body of law. So it can legitimately say there's only one way to interpret national treatment or whatever. Arbitrators are faced with the fact that there are 3,200 bilateral treaties, 60 more regional trade agreements with investment chapters. There's not one body of law. There are literally thousands of treaties, many of which are framed in relatively similar terms, but almost never in exactly the same terms. So legally speaking, an arbitrator can't just say, well, there's a general principle and I'm applying that general principle. They've got to apply the treaty on which the complaint is based. So that initial analogy of one court will bring rationality to the whole system has to be doubted. The next problem is, let's say you want a global appeal court. And naturally, there should be appeals from every one of these treaties. You have to amend 3,200 treaties and 60 major trade agreements. You have to amend the International Energy Charter. Think of it, amending 3,300 plus treaties. These things don't happen. At least they don't happen easily. They're very complicated. They're very difficult to achieve. So that in itself is very, raises a host of problems. And then getting more technical, people say, let's have an appeal process. Well, an appeal from what? The arbitration decision? They are applied through many different organizations, each one of which has its own rules of procedure. Not clear that it will be easy to amend all these rules of procedure. There is one which applies to roughly 1/3, the ICSID, the International Convention for the Settlement of Investment Disputes. About 1/3 of these investor state cases go through ICSID. It currently has a rather unsatisfactory appeal committee process, which only leads to total nullity of the award. If you could make an appeal process there, that might apply to about 1/3 of the cases, provided everybody wanted to have an appeal process. This was actually tried 10 years ago, and there were no takers. There were no takers. And yet you've got the context, you've got the treaty, you would only have to change about 3 articles of that treaty to alter the process. And the advantage of that treaty from the arbitration point of view is that there's no link with domestic courts. If you go to ICSID, that's it. So you could graft on an appellate process. But you have to get a certain number of states sufficiently enthusiastic to sit down, negotiate, and agree on this. They tried 10 years ago. Maybe the things have changed. Maybe they could do it now. But the question still remains, apart from ICSID, from what do you appeal? The arbitration award, or, and most arbitrations are subject to the supervision of domestic courts. They occur within the domestic legal procedural framework, and if they go seriously wrong, they can be taken back to the domestic court. Now, those who say they want an appeal process, do they want to cut out the domestic courts? I think they'd be surprised if they discovered that was the consequence. Or do they want an appeal from the domestic court? How would you like to see an appeal to a global arbitral appeal court from the Supreme Court of Canada? Think that's a good idea? And this is rather technical stuff I'm taking you into, but these are the kinds of reasons people say, well, why haven't we got this already? But part of the answer is there are immense difficulties in getting there, even if you can be convinced that getting there is where you want to go. So I give you that example. Another one, and let me take another argument, one of the big arguments, particularly, and this you hear particularly between developed democracies. We have good courts. uncorruptible judges who render judgments in reasonably expeditious time. Why don't we just use them? And I think that's a perfectly fair argument in itself. Until you come across the odd case where, in developed democracies, where in fact a government was sufficiently angry or vindictive to say, we're going to get these guys. That's what happened in the Bowater arbitration case a few years ago. Newfoundland was so mad at the Bowater Company, they said, we are going to expropriate them, and they write into the law, the Expropriation Act does not apply. We will give them whatever cash we think they deserve, and Newfoundland didn't think they deserved a penny. Okay, so you can find a few cases where, in fact, even a developed democracy has decided to cut a few corners and maybe make it impossible to go to court. And you can ask, you have to, and one of the things I'm trying to do in papers I'm preparing is to look at this very question: how many NAFTA cases could or could not have been easily resolved by domestic courts? And as I say, many of them probably could, probably not as quickly, but many of them could in developed democracies. The big argument in favor of investor-state arbitration between the developed and developing world is that the courts of developing countries are less open and less trustworthy and less effective, and therefore you need an arbitral situation where you choose your judges, you know what law is going to apply, you know what kind of procedure will apply. That's the real advantage of investor-state arbitration. You're spared having to go into the domestic courts. You know exactly what your legal situation will be and how you will be judged. And both parties are on the same terms, the government and the private parties. Now, people say, well, in developed democracies, that paradigm isn't appropriate. And as I say, you then have to go through all the criticisms that I don't have time to do this, but you have to look at all these criticisms. But one of them being, is arbitration itself undemocratic? Is two people with a commercial dispute in Canadian law, but pretty well around the world, can now choose their judges and put the case to them and ask them to decide the case in accordance with the law applicable. 50 years ago, that was much less difficult, much less acceptable, even in Canada, but our courts are overburdened, and more and more we have tried to push a lot of cases into arbitration. Is that undemocratic? Is that wrong? If all arbitration had to cease, we'd have to name a whole lot of new judges and expand the court system very considerably. We also allow all sorts of highly sensitive intellectual property or competition law cases to go to arbitration. Is it so extraordinary that we say investor-state cases can proceed? Or is that, and that's the kind of issue you have to look at if you're trying to analyze whether this is suitable in a democratic society or not. The question of the regulatory chill is another one you hear a lot about. it's argued that because investor state arbitration exists, regulators, officials, governments are afraid to regulate. Is that true? You hear it, but I've never seen a convincing case of regulatory chill. But you've certainly heard the expression. You all know the expression, regulatory chill. Sounds bad. Chilling. But are there actually cases where this has occurred? Well, look, I've given you simply one tiny part of my paper dealing with some of the criticisms. What I also attempt to deal with then is the solutions and the kinds of proposals that are made for different options. Perhaps, since I've only got a few minutes left here before question period, let me just give you my ideas as to what might be realistic options for the Canadian government. The first one is what they are currently doing. That is, if you look at the CETA text, or the Canadian Model Bilateral Investment Protection Agreement, they both contain investor state arbitration, but they also contain a lot of procedural refinements that mean that the process is much more open. You can no longer have secret arbitrations. It has to be transparent, open, public. And also, there are many exceptions and clarifications designed to protect public policy making, so that governments have heard the criticisms and they've said, okay, well, we write these into our new agreements. The current CETA text, for instance, is 37 pages long, whereas you go back, it's much longer than the NAFTA text, which itself was a much more complex text than the average investor state case, treaty. So governments have listened and they said, we've got to make the process more transparent. We've got to clarify the rules to make sure that they can't be abused or can't be used to limit legitimate public policy making. Governments also have the option, if they want, they can get together and work to create an appellate process within the ICSID format. If they want an appellate process for CETA or for the TPP or TTIP, they can have self-standing appellate processes for each new major agreement. I think going back and trying to amend 3,000 existing agreements is hardly feasible, but there are ways of making fairly concrete ad hoc steps to build an appellate process in the future. And they could also try to amend the rules of the various arbitration bodies that administer arbitrations. There's also a code put out recently by the United Nations, the UNCITRAL, so-called transparency rules, which can be adopted by all states if they wish. So there are a variety of procedural and substantive ways of tightening the process, protecting public policy decision-making. One can imagine an attempt to have a single multilateral agreement on investment. That was tried and it failed in 1998. That's, I think, unlikely to happen, but if you wanted a single common standard for all countries, that would be the way to go. One could also amend the trade-related the trade-related investment measures agreement of the World Trade Organization to expand that. You would then make it a pure public dispute settlement system, which many critics would like to see. But it would be far more invasive than simply having to pay damages, which is the current outcome. Would it be appropriate simply to say, well, developed democracies don't need it, so as between ourselves, we will abandon it in NAFTA, we'll abandon it in the Energy Treaty Charter and in any bilaterals that we may have, but we'll maintain it with the rest of the world. Could developed democracies do that? And that's really the object of my study and my conference. This would involve literally developed democracies saying, we don't need it, but the rest of you do. I'm trying to keep an open mind, but I'm fairly skeptical that this would be in any way appropriate. Could we limit the application of investor state arbitration to situations where there is demonstrably no effective domestic remedy? That's something that can be explored. Therefore, limiting the scope of what currently exists and thereby protecting the integrity of domestic courts more. I think that's worth examining, but it's easily said, it's not at all easily achieved. And I think that goes for virtually all the criticisms that can be made of investor state arbitration. So let me stop here. I'm sure you've got lots of ideas and lots of comments. I'll be glad to try to respond to them. Is it a work of the devil? Tell me, is it? Yeah.
Thank you very much, Professor de Mestral. One of the things that I've always wondered about is, and when I read your paper, it sort of reinforced this view, is how these criticisms might work in combination and work against each other, in the sense that arguments in favor of an appellate body and a sort of coherent body of law actually might be an answer in response to some of the undemocratic elements that people see in investor state arbitration, because it provides a more predictable and more public and coherent body of investor state law. And I'm just wondering, because the way you structured the paper is a sort of series of things, is how you see these different criticisms fitting together and the responses fitting together as well, because they seem to be working sometimes in opposite directions.
Well, I think you're right. What seem like very good ideas in principle may simply not work. And for instance, arbitrators will almost always, I think, tell you the whole purpose of arbitration, at least in the commercial sphere, is to resolve the case. And a great deal has been done through international action and in domestic law to ensure that domestic courts don't interfere, thereby allowing the loser in the arbitration to go to the court and say, it was unfair or something was wrong with it, therefore I ask you, the judge, to correct it all. Most countries now have a system whereby if you choose arbitration, the courts will send you back to arbitration if you try to go to them. So that there, I think, is one basic contradiction that I think many arbitrators will say, in fact, do you really want an appeal process? Do you want to potentially prolong most big cases by another 2 or 3 years, add on at least 50% more to the cost? What will be gained? Or will you gain sufficient advantage to make it worthwhile? And I think many arbitrators would say our gut feeling is it wouldn't really bring any particular advantage. Now, the proponents of the idea say this is a process that is not like commercial arbitration. It isn't just two parties that go off in the corner and choose their own judge. This involves a weighing of a number of public issues as well as private. There's private loss, but there are public regulation involved, and therefore the analogy with commercial arbitration doesn't hold. And so it would be of advantage to have a process where you would gain both respect for the whole process by having a court whose decisions would be regarded with greater trust. But as you say, I think they often cut both ways.
Thank you.
Thanks very much for your remarks. I'm very interested in what you mentioned at the outset about the confluence between international investment law and international trade law. And I guess just maybe what might be a very basic question, what is the qualitative difference between what a bilateral investment treaty delivers versus what an investment chapter in a trade agreement delivers? Are these 6 of one, half a dozen of another, or are they actually somehow qualitatively different such that a government would opt for one as opposed to another?
No, I think they're pretty much the same in terms of what they deliver. Indeed, you've got some arbitrations that make the point that the violation of other chapters of the trade agreement doesn't mean you violated the investment chapter. And they use pretty much the same words and the same approach in either a bilateral treaty or a trade treaty. You often see as well, for instance, our relations with China, we weren't ready, Canada wasn't ready for a trade agreement, but it seemed like a good idea to move forward and take one step, and the Chinese were eager to do this, so we negotiated an investment protection agreement. And that often happens. The investment agreement is seen as a first step toward something bigger, but normally there isn't that vast difference. On the other hand, there is an interrelationship. And if you start asking yourself, well, what do the service chapters and the commitments in the chapters on services do? Or what do the commitments in the WTO GATS services agreement do that are so different from investment protection? The answer is there's a huge overlap, particularly if you take financial services. You end up doing one thing or another. Or you take European Union law, which has this concept of freedom of establishment. In many ways, and yet they don't have a freedom of investment. They do have freedom of capital, but they have freedom of establishment, and that means individuals and companies can, in fact, invest by moving and setting up shop, and the establishment can be done by an individual professional person or by a big financial services company or any kind of company. So that there's a lot, in fact, a lot of overlap between the rules which are used to protect trade or investment. And I think it's fair to say that in the long run, we're recognizing that trade and investment are very closely related and ought to be dealt with, and are probably better dealt with. And there are people who say that in the long run we're going to see fewer and fewer bilateral investment agreements and more pure trade agreements, including investment protection. And let's say TPP goes through, there'll be a whole bunch of bilateral investment agreements that will disappear. Similarly, CETA, there will be our investment agreements with 5 European countries will be overtaken by CETA, and if the US and EU negotiate, same thing will happen. So that we've begun to see possible disappearance of a number of investment agreements as well.
Thank you very much for your talk. And this isn't an area of expertise for me, so forgive me if this sounds a stupid question. But I understand the premise at the beginning with the Germany-Pakistan agreement. I kind of understand that in the context of there's a lack of trust. Okay, so in order to facilitate these agreements, we have to compensate for that lack of trust in systems of governance in Pakistan for those German investors. So then when we get to the current era, where we have these protections in effect in place for developed countries, what is that about then? Is it still about a lack of trust, or is it about some kind of preferential treatment for capital or for investment? I'm kind of interested in whether that similar argument from the earlier period to the later still carries over when we're talking about developed to developed country agreements. And then I had another question, which was to ask you about your tie.
Oh.
Yes.
Well, to answer that first, strictly pedagogical. It's not necessarily my position, but I was given it by a member of the Japanese Diet a couple of months ago when I was in Japan, and this gentleman represents a rural constituency, and his constituents view any change in the situation of agriculture to be an unmitigated evil. Therefore, he knows that the TPP is an unmitigated evil for his constituents, and that's enough for him. So stop the TPP. But there is this idea that, and they're using the argument that investor state arbitration will be a part of it, and that will be used by foreign interests to challenge government policies. As I say, I'm somewhat skeptical of that argument. Canada's had NAFTA for 20 years, and we haven't had that many big American companies coming in and leaning on us. Protection of capital, I think, is the long-run purpose. Right or wrong, I think that is the purpose. Investments are made, and I think that's why people feel instinctively somewhat uncomfortable. They say, well, why do we need to protect Americans, especially in Canada, or Europeans? Now, part of the answer may be you ask, well, why did Canada, when it sat down with the European Union, simply not say, well, we don't need this stuff, you know? Ask yourself why Canada wanted it. I believe we were the demandeur. Well, sure, every country in European Union is a certified democracy, but, you know, there have been some problems in some of the Eastern European countries, haven't there? There's one country which will remain completely nameless, but in the north, it takes an absolute minimum of 7 years to complete a civil law case, an absolute minimum of 9 years to complete in the south. I don't know what country that is, but So you ask yourself, did the Canadian government behave rationally when they said, you know, we already have some protections in Poland and Hungary and a couple of the Baltic countries. Let's just roll them into the CETA. Interestingly, there are 190 bilaterals between Germany, France, Spain, Italy, and Netherlands, and former communist countries. They're still technically in place. They're still being used. And the governments of Netherlands and Germany and France, when asked by the European Union, why don't you get rid of them, simply say, we think they're a good thing. So protection against aberrant cases, I guess when the European Union looked at us, they thought about Sheila Copps in the first two NAFTA cases, which were completely avoidable. She was actually told, you will be sued, you will lose. She said, do it anyway. And then the Bowater litigation. So 3 out of the 31 were situations where the various Canadian governments could have behaved otherwise and didn't. So I guess the European Union said to themselves, well, if Canada wants protection in Romania, I guess we want to be protected in Newfoundland. Rather marginal stuff as far as I'm concerned. If we didn't have it, the world isn't going to change. The bigger question is probably, let's say we did forswear investor state arbitration. How's the rest of the world going to, just between ourselves, between Canada and Europe, or Canada and USA, what's the rest of the world going to say? We've got these 3,200 bilaterals with the rest of the world. Are they going to say, well, I guess it's fair enough, you know, we want your money, therefore we have to pay the price? South Africa is already challenging the whole thing. You hear Indonesia isn't too happy. India has come out with a new bilateral model. Bolivia, Venezuela, Ecuador are getting out of the ICSID. So there's some challenge to the whole system. And I think it ill befits the countries that created the system simply to say, for ourselves, we don't need it. We could. I mean, among ourselves, it's not going to make a big difference. We could have lived without Chapter 11 of NAFTA. It wouldn't probably everybody in Canada would be happier. But there's the broader picture, and the most complex case would be the energy agreement, international energy agreement, which the European Union countries negotiated with Caucasus, Central Asia. Would they go back and say, well, between ourselves, we can't be sued, but we can still sue you? And the case that's got the Germans all excited, the Vattenfall case, you have a Swedish company that owns a nuclear energy plant power plant in Germany, has been told, like 6 other power plants owned by Germans, you're going to close. We're phasing you out. So they're suing the German government, saying, you know, you're both procedurally and substantively, you're taking away rights unfairly. They're using the energy charter, but there are 5 German companies that are suing the German government before the German courts for exactly the same thing. Does it make that much of a difference? Vattenfall could doubtless sue in the German courts. That's one answer. But I think they want to keep the energy charter. There are enough European interests in the rest of the world to be protected that it would be very difficult to renegotiate that agreement. So I think part of the reason why do we keep it is we've gone too far down the road to easily pull back. It's conceivable that we would pull back, but there would be costs, might be huge costs. The day the Canadian government says we're giving up on investor state protection, I think they'd hear from a lot of people who don't normally talk and say anything publicly, but have a lot of influence. But so protecting capital, I think, remains central purpose.
I come from economics background, and we're always undecided about investor state.
Yeah, yeah.
On the one hand, we think maybe it's a good thing in terms of providing some kind of due diligence on the governments to do things for a good social whatever reason. But we're also, again, this idea that, well, wait a minute, it seems to put the foreign firms at an advantage relative to domestic firms, as you just pointed out in the German case. But I wonder if there is a case that might be viewed as the kind of poster child for what's wrong with investor state that you actually think is a case about what's right about investor state dispute settlement.
Well, I get the one that's got everybody upset in, I think the German case is a bit fallacious because the rights, the same rights that are being claimed under arbitration exist in German law. The one that is most noted right now is the Philip Morris action. Well, there are two of them. One in Australia, which has got enormous press and has made everybody very unhappy about the idea of investor state arbitration. But they're also in not Ecuador. Uruguay, excuse me. And they're also making the same claim that they have lost money because of plain packaging legislation. But, I mean, these are people who have unlimited amounts of money and will go to any court and have gone to any court. But, I mean, the fact they've just lost a huge case in Quebec this week. Took 15 years to beat them down. There were big litigation in British Columbia, and twice they've challenged freedom of expression under the Charter. Twice they've lost. But that's hardly an argument to say they shouldn't be allowed to go to court, is it? But, I mean, if you want an example of what brings investor-state arbitration into a very bad odor, it's certainly that kind of litigation. Now, the Bowater, if you want a Canadian example, I guess the Bowater is the best because they're a province expropriated deliberately without compensating. And they had no remedy. They had no remedy. They could have complained under international law and got some foreign government to sue the Canadian government, but it'd be slow, difficult, and that's one of the reasons we have this whole investor-state system, that the old international claims system never worked very well and was highly politicized. But I guess if you want more arguments in favor, you can look around the world to a lot of situations where investors have been badly treated and have been able to vindicate their rights using investor-state arbitration. I mean, there's a famous case in Egypt where people bought a hotel and thought they were going to build it up and make money and what have you. And for whatever reason, the local authorities wanted the hotel for themselves or their friends and set the police on them as soon as they arrived. Never let them in, and then when they tried to come in, beat them up, put them in jail, and made it totally impossible for them to realize their investment. That's the Wena Hotel case. I mean, so there are cases both ends of the spectrum, and probably quite a few in the middle.
think we're just about at the end, but I think this is certainly one of these areas where sort of watch this space, both in terms of the unfolding public debate around investor-state arbitration that I think probably will unfold as some of these trade agreements become debated politically, and also watch this space in terms of Professor de Mestral's work with CIGI and the papers that are coming out of that project. So thank you, Armand, and it was a wonderful talk, and thank you for being here. Agreements on the horizon where investor-state arbitration is taking a significant or potentially significant role. And in that regard, we have really a first-rate navigator of this complicated landscape. Armand de Mestral is a professor emeritus at McGill Law School. He's currently the Jean Monnet Chair in the Law of International Economic Integration. He teaches and researches in the area of trade law, international arbitration, and the law of European community. And he is an extremely well-known and well-respected international legal scholar in Canada, and indeed all over the world. He's served on WTO and NAFTA dispute settlement and arbitration tribunals, and also has served as the president of the Canadian Red Cross. He's a member of the Order of Canada, and brings a huge amount of expertise, and is currently bringing that expertise to CIGI as a senior fellow. So it's really with great pride and great delight that I introduce Armand de Mestral.
Well, thank you very much, Neil. It's a pleasure to be here, to have an opportunity to speak to, and also I hope hear from such a varied group of students of international relations, international law, and international affairs. Now, and also, of course, I'm very pleased to be associated with the CIGI. We're working toward a conference on September 25th, and possibly a publication subsequent to that. Now, my topic is a rather focused one, and indeed I'll just give you the precise topic that I'm focusing on in the study is whether it's appropriate for developed democracies to have recourse to investor-state arbitration. So responding, if you will, to the kind of concerns or unease that Neil just alluded to. But I hope I can show you that this is not just a narrow issue. In fact, it raises a lot of cross-cutting themes in international relations, international law today. We're looking at the whole question of the pertinence of the treaty protection of international investment. We're looking at the confluence, if you will, the coming together of international trade law and international investment law, two fields that for quite a while and still in many ways are rather separate, but seem to be coming together. We're talking about the significance of regional trade agreements as opposed to, or sometimes in conflict with, the global system epitomized by the WTO. We're looking at the issue of the universality, the appropriateness of the universal solutions versus particular solutions. should the same rules apply in the same way to all countries? And we're also looking at a very political question, a very serious question that Canada may have to answer fairly soon in the context of the CETA, because over 3,000 bilateral treaties designed to protect foreign investment moving from investor countries to investment in countries receiving investment, mainly between developed and developing countries. We've seen the emergence over this 50-year period of roughly 3,000 treaties. And in recent years, we've seen an additional, if you will, complication that many of the regional trade agreements, so broader trade agreements like NAFTA. NAFTA was really the first one that really set the course 20 years ago. We're seeing chapters on investment protection, which written into trade agreements, so that trade and investment law are coming together. And a central feature of most of these bilateral treaties and of these texts like NAFTA Chapter 11 is a system of arbitration which allows the private investor who considers that their investment has suffered economic loss due to violation of the standards of treatment set out in the treaty, the investor is permitted to seek arbitration directly against the state that they think has caused its economic harm. And this is what is known as Investor State Arbitration. You also see the expression Investor State Dispute Settlement. I find that a little ambiguous because that might embrace also public dispute settlement. What I'm talking about is a private investor suing a government, which makes, we have an agreement with the European Union right now, which includes investor state arbitration. We're hearing more and more from certain quarters, but not necessarily from everybody in the European Union, that they're uneasy with it. And the one committee of the European Parliament has even said it ought to be withdrawn from CETA. That, of course, is just the opinion of one committee, not of the member states, not of the Commission, not of the EU as such. But it's nevertheless something, the text of CETA is being finalized at this moment, and it's conceivable that we may have to look again at something we assumed was settled. So that makes it, I think, a very timely topic, and whether it will be resolved by September 25th when we have the conference, I'm not sure. But so what I'd like to say, talk to you, first set out briefly, how did we get to this situation? Then, secondly, I want to review some of the criticisms that are made of investor state arbitration. And then, thirdly, look at some of the solutions that are proposed. And finally, if there's time, to look at some of what I think are the options that are realistically available to the Government of Canada at the present time. Now, as I say, the topic is the pertinence, the propriety of investor-state arbitration between developed democracies. And why am I asking this question? And where does it come from? Now, since roughly 1959, we've seen the development of roughly
Welcome to the International Law Summer Institute's guest faculty lecture 4.0, and it's a real pleasure to have Armand de Mestral as our guest speaker today. The issue of investor state arbitrations has been something that's always really fascinated me as an environmental lawyer because of the interplay between investment and the environment, and particularly in the NAFTA context, because Chapter 11 of NAFTA was always one of these issues that I personally looked at and felt it was a bit like bulk water in Canada. You know, it seemed to be much fuss, but when you actually looked at the cases and what went on, and perhaps until the Bilcon case that just came out, which is changing my view a little bit on investor state arbitration. But it's such a nuanced area and such a controversial area for many good reasons, and I think it's certainly an area that deserves a sort of comprehensive taking stock of where we are with investor state arbitration, because we seem to be moving into perhaps another era with a number of trade and investment